The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we'll begin argument this morning in number 24129, United States v. Friend. And Mr. Wagner, when you're ready, we'd be happy to hear from you.
Thank you so much, Your Honor. Good morning, and may it please the court. I'm here before the court on behalf of Mr. Friend for the second appeal of his Miller resentencing proceedings to address the reasonableness of a 52-year sentence imposed on a 15-year-old who was under the influence of his more blameworthy family members. The overriding concern we have with the district court's opinion is the simple premise that a child is different, and a case involving a child must be handled differently by our courts. This distinction was not at all apparent in the district court's opinion and sentence in this case. In the first case, the district court imposed a sentence of 65 years, 780 months, 5 years above the sentence requested by the government. This court vacated the sentence and remanded for resentencing. This court provided the district court with very specific instructions on remand. It mandated that the district court explicitly weigh against the aggravating factors, one, the fact that Mr. Friend was 15 years old at the time of the offense, two, that Mr. Friend would have trouble getting away from the influence of his family members, and three, that Mr. Friend's sentence in relation to his more culpable...
The district court was well aware of Mr. Friend's age, was he not?
They certainly should have been, but that was not apparent from the decision of the district court. In fact, never in the district court's opinion did the district court ever specifically say that Mr. Friend was 15 years old. And this had implications beyond...
Counsel,
Yes,
just
Judge.
to back up a second. I mean, the whole premise of this, if he wasn't 15, we wouldn't have had the first Miller resentencing, much less the second Miller resentencing. To suggest the judge didn't know that he was a juvenile, it's a little hard.
I'm sorry, Judge. If I gave that impression, I didn't mean to. Of course, he knew he was a juvenile, and he certainly knew that he was 15 years old, but he didn't acknowledge the specific age of Mr. Friend in his opinion. And he didn't distinguish the fact that a 15-year-old perhaps should be treated differently than a 16 or 17-year-old. Mr. Friend, as a 15-year-old, was on the very lowest end of the spectrum under the federal Miller resentencing. And he was given one of the harshest punishments of any federal Miller resentencing defendant. So the fact...
Mr. Wagner, my memory's not that good. Was there evidence presented to Judge Hudson about disparity in sentencing with similar type cases and similarly situated defendants?
Thank you, Judge. Yes, we went to painstaking measures to basically look into every single federal Miller resentencing that has come before the courts. We presented graphs and summaries of each of those cases to the district court. We actually used the services of the Juvenile Law Clinic at the University of Richmond Law School to prepare these materials for the district court. And they did really a great job. Professor McConnell from the University of Richmond Law School testified at the hearing and presented every single federal Miller resentencing case that they could find. And in presenting that, they showed that the 65-year sentence that Judge Hudson imposed previously was an outlier, a significant outlier. And now even the 52-year sentence that he imposed. Well,
there was a significant reduction in response to our mandate and at the resentencing, was there not, from 65 to 52 years?
Of course, Judge, yes, a 13-year reduction. And that reduction...
I mean, that's pretty substantial. That wouldn't be a a sign that that kind of a reduction would indicate that the judge was sensitive to our mandate and didn't ignore it, wouldn't it?
Well, to the mandate generally of the case being remanded to the district court, but not the specific matters that this court in its last decision gave to the district court to adhere to. For instance, this court said that Mr. Friend would have trouble getting out from under the influence of his family members. This is something that the district court never addressed in its decision, never even touched on. Talk a little bit about the influence of the family
I'm
members.
sorry, wait one second.
Yes, Judge.
You're suggesting that our prior opinion in this case found that he would have trouble?
Well, it was an issue that this court explicitly directed the district court to address on remand. And
Right. Well, but
appeared,
that's not a suggestion that we made a factual finding to that effect that bound the district court, right? We're just saying these were issues that were raised, and the district court needs to consider them.
well, the words of this court were, and I quote, that Mr. Friend would have trouble getting away from the influence of the family members, and that the court should address these, and that Mr. Friend was less blameworthy, quoting, less blameworthy than his brothers, and the district court should address that. So my construction of that is that was, in essence, a finding of this court. You all made the decision, Judge. You know what your finding was, but that was my reading of the decision of this court. And then, after laying out these three factors for the district court to address, this court said that the district court must explicitly weigh each of those factors. And the district court...
Mr. Wagner, what do you do with the fact that the advisory guidelines recommendation was for a life sentence? And I realize you regard that the sentence that was given of 52 years as very lengthy, but it was still below the advisory guideline recommendation, was it not?
It certainly was, Judge, but this case is different than most cases that deal with the guidelines. This case involves a child in a Miller resentencing. And once a child is found not to be permanently incorrigible, then the guidelines really don't apply. And that's exactly what this case involves and what this court should be concerned with. The guidelines in every federal Miller resentencing case were, as far as I know, were mandatory life. And that's why they were brought back for resentencing, because the U.S. Supreme Court determined in Miller and Montgomery that a permanently incorrigible juvenile is the only juvenile that could be sentenced to life under these circumstances. Mr. Friend was found to be an exemplary model of rehabilitation by Mr. Donson, who testified in the first Miller resentencing hearing. The court found that he had rehabilitated himself. He was not permanently incorrigible. And so the guidelines don't necessarily apply to a case like this, Judge, as in every federal Miller resentencing case. What matters, Judge, I would suggest to the court, are the 3553A factors. And when you balance the 3553A factors, especially 3553A6, when you look at the unwarranted disparity between the 52-year sentence in this case and the sentences in every other federal Miller resentencing case, you see that this again is an outlier. That this case, that Mr. Friend was subjected to a much harsher punishment than virtually all of the other federal Miller resentencing defendants.
Well, of course, each of these sentences is supposed to be an individualized matter, and it seemed to me that the district judge tried to make it here. But I mean, we can't dance around the fact that Mr. Friend's role in these carjackings and the treatment of these truck drivers was just truly brutal. And when you talked about the influence of family members, and that he was more than just a follower, or he was not acting at the behest or command of a family member. And there was one instance in one of the carjackings where Eugene actually, as I understand it, had to pull Phillips away because he was afraid that Philip was going to kill the driver. So, at least in that instance, I thought the family member was acting almost as a restraining influence on Philip, if you can put it that way. And the testimony in JA 204 and 214 say Eugene pulled the defendant off the driver at one point, quote, because he was afraid his youngest brother was going to kill him. And I think that's what bothered the district judge, is that there wasn't, this is not an example of passivity.
Right. And we certainly acknowledge that, Judge. But if you look, and you talk about individualized sentencing, Judge, and that clearly is something that the district court needs to do. But what we did in presenting the summaries of every single Miller federal resentencing case to the district court was show the facts and circumstances of those cases, the criminal histories of the defendants, and more importantly, the prison records, the rehabilitation patterns of each of those defendants. And one thing that is clear, Judge, is that as heinous and as serious as the criminal conduct was in this case, and specifically by Mr. Friend, he didn't kill anyone, Judge. The trigger man for the murders in this case was one of his brothers. But if you look at every single one of those other cases, they're all notorious. They all involve very serious, violent acts. They all involve murders, which resulted in life sentences for the defendants. And they all resulted in sentences, almost all resulted in sentences far lower than what Mr. Friend received. Sentences between 25 and 40 years. Nowhere near the reduction that Mr. Friend received. I want to actually focus on a couple of those cases. For instance, the Sparks case from the Fifth Circuit, which has been cited by the government in their pleadings. Judge, that involved the kidnapping, murder, and burning of youth ministers after they gave the defendant Sparks a ride in the car. It involved horrible conduct in prison. An individual who tried to escape. His co-defendant strangled the guard unconscious while awaiting trial in that case. And the court in Texas, the district court, gave Mr. Sparks a 35-year sentence. Clearly, conduct far more egregious than what we have that Mr. Friend personally did. Look at the Thomas case from Maryland in this circuit. A 17-year-old involved in a 3-year drug conspiracy. Federal prosecutors linked him to 6 murders, including being paid to kill a federal grand jury witness. The district court in that case imposed a 40-year sentence. The Jefferson case, 16-year-old, and then 17 in another of the incidents in that case. A firebombing of a home in which 5 children were killed. And then a gang shooting, an innocent bystander killed. 6 bodies in that case, similar to the Thomas case. A 50-year sentence, 2 years less than what Mr. Friend received in this case. One of the things that we pointed out in these comparisons between all of the federal Miller resentencing is that you had primary offenders who were sentenced much more harshly than secondary offenders.
But isn't the guidelines recommendation, doesn't that take into account the fact that, doesn't that take into account what a sentence should be? In other words, the guidelines, I assume the Sentencing Commission, when it draws up these recommendations, is fairly aware of the fact that there are going to be individual circumstances and, different cases before different judges are going to result in some disparities. But I think that the Sentencing Commission is acting with those disparities as a kind of a background context, and then it comes up with a conclusion which said, okay, the nature of this crime is such that we're recommending this particular sentence. And this was, in fact, not only within the guidelines range, but it was, as we know, below. But what I'm wondering is, don't the guidelines act in the context of knowing that there are going to be variations in sentencings, and yet taking those variations into account, they come up with a recommendation as to the severity of the crime and what offense level it recommends. You see what I'm saying?
I do, Judge. And in the standard case that comes before this court, in the run-of-the-mill case that comes before this court, certainly the sentencing guidelines would be critical to this court's review of the case. But I see my time is running out. Can I conclude my response to your question, Judge?
Would you like to do it now? Do you want to do it in rebuttal? I'll go ahead
very briefly.
Go ahead and respond now, Mr. Wagner. I'll be happy to hear from you.
Thank you, Judge. Just to say, Judge, that in the Miller resentencing context, that the guidelines really don't matter. And every court that have addressed Miller federal resentencings have held that the guidelines are not what the court is to look to in terms of guiding the sentences in these cases. It's 3553A factors. And those factors in this case, Judge, weigh heavily against a sentence of 52 years. There are no more questions
All right.
at this time.
Thank you very much, Mr. Wagner. And you have some rebuttal time.
Thank you.
And I'm going to, before you sit down, Mr. Wagner, I always like to ask my co-panelists if they have any further questions of you, Judge Floyd or Judge Richardson. Do either one of you have any further questions of Mr. Wagner?
No, sir.
No, sir.
All right, well, then let's hear from Mr. Cook.
May it please the court. I'd like to begin with the disparity point the defendant was emphasizing. As the government pointed out in its 28J letter filed earlier this year, the Eighth Circuit recently upheld in Barraza a 50-year sentence for a 16-year-old who committed kidnapping and murder of a woman and her 5-year-old son. The Second Circuit in Portillo recently upheld a 55-year sentence for a 15-year-old who participated in murdering 4 people in a gang attack. So the defendant's sentence in this case is really not out of line with sentences post-Miller that have been affirmed. As to the court's explanation on the disparity, I'd like to focus on first 3 factors that the district judge mentioned that were important for its assessment of the sentence in this case, and that were the sentences of the co-defendants in this case, which were all life and remain life, the guideline range of life, and then the sentences in the other Miller resentencings. And the district judge discussed the testimony that the defendant presented at the resentencing, the most recent one, reviewing the sentences in other Miller resentencings, and the court described that as, quote, a major factor, and that's Joint Appendix page 831 in its sentence. And that, of course, fits with the fact that the judge went from a 65-year sentence down to a 52-year sentence. So right there, the judge gives this court a direct statement about what's different in the resentencing and what drove the court's determination. As it said, this is a major factor, is looking at these other sentences, and they're simply well within the range of what, as Barraza and Portillo show, courts have upheld. that also fits with this court's case law, which says that comparisons of defendants is inherently very difficult because there are always distinguishing factors among them and unique circumstances. And so that then leads me to the court's discussion about the defendant's age and the expert testimony that the defendant presented, which was extensive about how Philip Friend's youth, his circumstances in his family, the childhood that he had, would be weighed against the gravity of the crime. And ultimately, I don't think that the explanation requirement in 3553C, which requires a statement of reasons from the court, requires a court to do something akin to saying, well, look, Philip Friend beat John Cummings for 6 hours. Cummings lost his sight in one eye, hearing in another eye. He testified at the first sentencing that he couldn't even cut grass anymore. And have that level of granularity in discussing the harm to Mr. Cummings versus the defendant's interest in a shorter sentence. And similarly, when it comes to Sam Lamb, the defendant knew already that his family had murdered Soren Cornforth. The defendant himself had beaten John Cummings for 6 hours, and Eugene had to stop the defendant from killing John Cummings. And Judge Payne, the first judge, concluded that it was only Eugene's intervention that prevented Cummings' death. And then the defendant put a bag over Sam Lamb's head and taped it and proceeded to beat him for 50 minutes. These are very unique facts, and a court, I don't think, has to, in what is ultimately kind of an incommensurable comparison of the defendant's interest in a shorter sentence, the victims and their family members' very, very serious harms, and how those are balanced out, and taking into account public safety as well. It's, I think, recognized that this is ultimately a judgment call. What you want to have from the record is a clear indication that the court gave serious consideration, grappled and weighed these competing considerations.
Counsel, Mr. Cook, so we send this back on a procedural error, sort of a blue error. And on remand, the district court, understanding sort of the discussion you've had about the details he provided, reduced the sentence 20%. And I just wonder, you see a lot of these, and you may get some insight on what happens when they come back down. Is that an unusual degree of reduction for these sort of blue resentencings or procedural error resentencings? Or is that sort of consistent? Do you have a sense of how we ought to think about that degree of a reduction for a blue resentencing?
I candidly, I don't know that I could generalize about what happens on failure to explain remands. Sometimes nothing changes, but sometimes the sentence does. And I do think in this case, the judge gave us the reason that really changed the sentence in this case, because I doubt that the judge's evaluation of the harm to the victims, the gravity of the crime, and the defendant's age changed that materially. I think what really drove the sentence is what he told us, which is that the defendant's efforts at showing the sentences imposed in other Miller resentencings really made a difference to him. He described that as a major factor.
Mr. Cook,
yes.
Mr. Cook, let me ask you this question. I'm going to be long gone and dead by the time Mr. Friend gets out if this sentence stands. Is it appropriate or reasonable to consider the fact that he will be 67 years old when he gets out, and he's been in prison since he was a young teenager?
I think that that's a factor a judge, it's certainly appropriate for him to consider. I think that the
Will he be 60 or 67?
Yeah. I don't think he'd be 67 at the date of his release. I believe that once you take into account good time credits, that it's closer to 60 that he would be released. That is a factor that the court can consider, but it's ultimately wrapped into the broad discretion that a district judge has. And so I don't think that the substantive reasonableness standard of review or even the Eighth Amendment standards would allow a court to say that this is a Eighth Amendment violation or that it's substantively unreasonable. And I think that
can you just take a second and on the Eighth Amendment question? First, do you agree that the Miller issue, or maybe Montgomery, better phrased, includes some term of years? If he had gotten a 900-year sentence, so not a mandatory life sentence, but a 900-year sentence, would that have violated Miller absent an incorrigibility finding?
The department's position, as I understand it, is that a term of years sentence can be an effective life sentence. And we've seen that in cases where, for example, in McKinley, the Seventh Circuit case, there was a 100-year sentence.
That's what I thought the answer was, but give me some thought, and maybe we don't have to address it here, but just whether it's yours or the department's generally, like how do we draw that line in determining when 900 years doesn't work? 40 years, I presume would certainly be acceptable to everyone. But how do we know where to draw that line? Do we have to look at actuarial tables? How are we even supposed to do that?
I do think that is one of the very hard questions that remains after Miller, and I don't think that any court has provided a definitive test. The Third Circuit and Grant came up with the retirement age standard that has been vacated en banc. We don't think that that makes sense. That although if you even accepting a retirement age, the sentence in this case, I think, is below that. Similarly, I don't think that some actuarial estimate of life expectancy makes sense, and making projections about life expectancy are very difficult. I will note, though, that the defendant...
Have there been any sentences after Miller that have struck down a term of years on the grounds that the term of years was too long?
I don't believe so. I mean, there's the example of Grant, which the panel there did, but that's been vacated on...
Well, I'm just wondering if there have been a court case in response to Judge Richardson's good question. I'm just wondering if there'd been a court case that has said this term of years is effectively life without parole, and in violation of Miller, even though it's nominally a term of years. I just wondered if there had been any of those cases.
I mean, courts have accepted that sentences that exceed really normal life expectancies, like 254 years, are de facto life sentences, and you need an incorrigibility determination to uphold it under Miller. But for sentences in the range that this sentence is here, so for example, Jefferson in the Eighth Circuit case, that was a 50-year sentence, not a de facto life sentence. Portillo, 55-year sentence for 15-year-old, that was a Second Circuit case, that was upheld. Barraza, the Eighth Circuit case, a 50-year sentence for a 16-year-old, that was upheld. So I don't think this court needs to come up with an ultimate test for when something is a de facto life sentence. Just in light of Barraza, Portillo, and Jefferson, the sentence here falls within the range that courts have accepted. And
Well, I guess the other point to make is, as I understand it, that Miller and Jefferson, they were talking about there not being a mandatory life without parole. I'm not sure that those cases says, you can impose life without parole, but you just can't do it as a mandatory matter. You have to look at the individual circumstances and the like. Is that correct?
Yes, I think that's right. I mean, when you're dealing
it's not a per se bar to life without parole in the case of a juvenile. It's a question of how a life, whether this isn't a life without parole sentence, probably in light of what you're talking about in the Eighth Circuit and the Second Circuit, but I did not understand those cases as an absolute bar to mandatory to life without parole, but I did understand them as saying there has to be an exercise of judgment, and there has to be you have to look at individual circumstances as a part of the exercise of district court discretion. Is that correct?
I agree with that, and I think when you are dealing with a case that is a life sentence, the Supreme Court's pending case of Jones versus Mississippi is going to shed some light on what exactly are the findings needed to post-Miller affirm that life sentence. And there the Supreme Court is looking at what sort of finding of incorrigibility has to be made in light of the combination of Miller and Montgomery. But this case just simply doesn't involve a life sentence. And so I don't think ultimately it's necessary to answer the question that is before the Supreme Court in Jones to decide this case. Essentially, Barraza, Portillo, Jefferson, those cases, and frankly, this court's opinion came as well, which again did deal with the life sentence, amply support that the court acted within its discretion here.
All right. Is there anything further that you have, Mr. Cook?
I'm happy to answer any additional questions that the court has, but otherwise I'll rest on the government's pleadings and ask that the court respectfully affirm the judgment.
All right, Judge Floyd, did you have any questions of Mr. Cook that you'd like to ask?
No, sir.
Judge Richardson, do you have some questions you'd like to ask?
No, sir.
All right. Mr. Wagner, you've got some time for rebuttal, so we'd be pleased to hear from you.
Thank you, Judge. I appreciate that. There are several points that I'd like to raise. Throughout the government's presentation here, just before I'm speaking, they referenced the Barraza case and the Portillo case. And Barraza, again, was a very, very serious case, a 50-year sentence. Again, a sentence lower than Mr. Friend received. And that was a kidnapping of a young woman and her 5-year-old child, the rape of the mother, and the killing of both the mother and the child, again, resulting in a 50-year sentence, which is less than the sentence imposed by Judge Hudson in this case. Now, the Portillo case, however, my reading of that case is that was not a federal Miller resentencing case. That was actually the first opportunity that the district court had to sentence Mr. Portillo.
I was under the impression that the 3553A factor that dealt with unwarranted disparities in sentencing was significantly aimed at co-defendants within not entirely, I recognize that, but that it was significantly aimed at co-defendants in a multi-defendant case, and where you seemingly confronted with people who sort of relatively or are culpable to the same degree, and yet one receives a very high sentence and one receives much less. Often that's because of substantial assistance or because some of them have pleaded out. But I thought that was part of what the unwarranted disparity and to my mind, doesn't the word unwarranted disparity, not just any disparity, but an unwarranted disparity,
Certainly, Judge.
is important.
Yes.
Um,
And one of the things you referenced when looking at the different sentences under 3553A6, certainly in some respects it applies to co-defendants, but also this court in McCoy made a finding on national statistics referencing a district court case, the Bryant case. And in that decision in McCoy, this court talked about the average murder sentence for 2018 was 291 months. And the court distinguished that 291-month sentence. This court distinguished that 291 sentence.
But average would imply that there are some cases below the average,
no question,
and some cases above the average.
Of course.
And so the question is, well, why is that? And
right.
The reason that there are some cases below it and some cases above it, which is what an average means, after all, is simply the fact that sentencing remains at heart a question of the discretion of the individual district judge, and sometimes things that may superficially appear to be disparities are actually the product of individualized considerations in sentencing, and particularly the sense that the judge has with the he has a sense and a grasp of the circumstances of the crime, and more than that, he has a grasp of the characteristics of the defendant and what kind of person, what kind of individual it is. And we can talk about averages and talk about nationwide statistics and everything, but isn't it important when the sun sets that we recognize that sentencing is supposed to be to a substantial extent involve an exercise of individual discretion in a particular case by a particular district judge?
Yes, sir. I certainly acknowledge. I see that my time is out, Judge, and exceeded by a minute. May I answer that question and by answering it, address the Eighth Amendment issue?
I will try not to go on for too long, but I always believe in giving a litigant the last word. So go ahead.
Thank you, Judge. Thank you. Well, I will say this, Judge, about disparities and about 3553A6 and avoiding unwarranted disparities. In this case, unlike only two other Miller federal resentencing cases, Mr. Friend pled guilty and accepted responsibility and expressed his remorse from the very beginning of this case, and always has apologized to the victims in this case. And with the Eighth Amendment overlay in this case, what the Seventh Circuit said, what the Ninth Circuit said, what the 10th Circuit said, what 7 state Supreme Courts said was that a term of years is something imposed in a Miller resentencing case, is something that has to allow the inmate a meaningful opportunity to return to society. That's what all of those courts said. And in those state court cases, the 7 state Supreme Courts said that a 50-year sentence does not allow a person who as a juvenile was sentenced to 50 years, does not allow that person a meaningful opportunity at life after prison. And so under the Eighth Amendment and under the rationale of those 7 Supreme Courts and under the rationale of the 7th Ninth, and 10th Circuits, this sentence of Mr. Friend is unconstitutional. And we would ask that the court reverse the district court and remand this case back to the district court for resentencing.
All right. Do either of my colleagues have any further questions?
Nothing from me.
All right. All right. I want to thank you, Mr. Wagner, and very much, and thank you, Mr. Cook. As we all know, we can't come down and exercise an honored Fourth Circuit tradition of shaking your hands personally, but we do want to say to each of you that there's no less of an appreciation of the services that each of you rendered to the court. And so thank you both, and the court will take a 5-minute recess, and then we will head directly into our next case.
Thank you, Judge.
The court will take a brief recess before hearing the next case. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, Mr. Levitt, we'd be happy to hear from you in DeCoco versus Rosen.
Thank you, Your Honor. This case involves who at the time was a 67-year-old psychiatrist employed as such by the Bureau of Prisons. The Bureau of Prisons at that time had a procedure that they called their physical ability test that required new hires to pass in order to keep their position in law enforcement. When the plaintiff was fired, she had been employed as a psychiatrist, not as a law enforcement officer. But the Bureau of Prisons had a sweeping requirement that everybody, no matter what you were hired for, was, in a case of emergency, a law enforcement officer, and therefore had to successfully complete the PAT, physical abilities test.
Well, I guess the rationale for it is that if you run into an emergency, it's an all hands on deck situation. I mean, there are many security forces that apply physical tests to all of its members. I know in our courthouse, the court security officers have to pass certain physical requirements, and a great many organizations which are in the business of providing security of one form or another. A lot of them, not all of them, but a good many of them have some sort of physical aptitude test. Well, this isn't necessarily that unusual, and I'm wondering if anytime you work through a system, or anytime you work through a system of classifications, there are always going to be some situations within the class that may appear inequitable. I was thinking when I read your case about the vaccine requirements for the COVID-19 and all the different classes that were the priorities, 1A and 1B and this and that, and within those classes there seem to be some very inequitable cases of inclusion or exclusion or whatever, but that kind of goes along with the ability to classify and to set rules, kind of goes along with the whole idea of governance, doesn't it?
Well, this case is a little bit different than that. In this case, she was not hired to be a law enforcement officer. She was hired as a 67-year-old psychiatrist and told that in order to keep that position, she had to pass the physical abilities test because of an
Mr. Levitt, can we get to the real issue in this case? there's an argument about standing, and my question to you is: is constructive discharge a question of fact or a question of law?
This is a question of fact, because it's a fact he was not hired as a law enforcement officer. She was hired as a psychiatrist and was required to meet the standards for a law enforcement officer to not only be hired, but to keep that law enforcer's job. Now, in her case, she was offered under their rules what they call a chance to take the physical ability test again, a second time. Now, she was told that if she took it a second time, she had to do it within 24 hours. At the age of 67 at that time, she was much younger than virtually everyone else, and had the physical abilities of a 67-year-old, not of a 36 or under year old. And when she was told that she could take the test the second time, she said, "I can't take the test the second time in 24 hours. I'm exhausted. I cannot take it and pass it." And what's interesting is, it's not that she never took the test. She did take the physical abilities test, and she was able to perform all of the things that were required under that test, lifting something while she was climbing a ladder and so forth and so on. Strenuous things. She took them all, was able to do them all, but not as quickly as younger people and as people who were males. And that's why
Can I ask, Mr. Levitt, can I ask you a separate question and sort of a narrow one? In count one of your complaint, which is your Title VII claim, you allege a violation of Section 2000E2. But that doesn't apply to federal employers, right? 2000E16 applies to federal employers. So E2 is simply inapplicable and cannot be applied against the federal government. Tell me why we should address the Title VII issues at all, given that you sued under a statute that does not apply to a federal employer.
Well,
that's only on the Title VII count. But why should we even consider those issues?
Well, she has two causes of action here. She has a civil rights cause of action under the Equal Employment Opportunity, and she has a claim that protects against age discrimination. And the things that
but to follow up on Judge Richardson's question, your claim seemed to be against the requirement here on the basis of disparate impact. And the question I have is that, and I think this was what Judge Richardson was aiming at, that 633 of the ADEA and 623 are written very differently. One of them appears to be aimed at anything which has an adverse effect. And if you were not a federal, if you were if this was a private institution, you might have some headway with that. But the under the Sandoval case, the statute that seems to be aimed at disparate treatment, not disparate effect, and the but it seems to me that the claim that you're raising sounds like an adverse effect or a disparate effect claim with respect to this requirement.
Well, this what
and I don't understand, and it may have a disparate effect, but I don't understand that to be the standard of the violation.
Well, the statute in the ADEA states very clearly that there shall not be any age discrimination. And it's an unlimited statement in the statute. That's it. And that means that you're not going to stop proceeding under that statute by virtue that there's no provision for disparate impact.
Mr. Levitt, let me ask you, what impact does Gomez Perez have on your position? Supreme Court case Gomez Perez. Does it help you out?
The ADEA federal sector provision that I was talking about was patterned directly after Title VII's federal sector discrimination ban. That statement is at page 4 of the brief. So,
but I'm still trying to get to the basis, because of 633 uses the words based on age, which seems to me a clear reference to some sort of disparate treatment or intentional discrimination. And when you look at the Sandoval case, you see that the language like on the grounds of or based on or on account of are all sort of intentionally focused. And yet your complaint with the test requirement employed by the division seems to be one of adverse effect. And there may well be an adverse effect, but I'm just not sure that the statute sets it up that way. I think the statute uses those words, if I recall correctly, based on age or whatever. I just think, well, Judge Richardson brought up the point, but it echoed a concern that I had.
Well, to answer your concern, Section 15 of the ADEA states in pertinent part, quote, all personnel actions affecting employees or applicants for employment who are at least 40 years of age, ... shall be made free from any discrimination based on age. 29 U.S.C. Section 633A.
Wouldn't your case have been a little bit stronger if you'd taken the second test?
Well,
or at least tried. Didn't matter whether you passed or failed. You might actually have passed, given the percentages of people who have passed, which have been in the 98% of applicants over 40 passed, and 98.6% of women applicants passed. And whether you passed or failed, wouldn't you have had a stronger case if you'd at least taken advantage of the chance to take a second test?
Well, in International Brotherhood of Teamsters versus U.S., 431 U.S. 24, 1977, quote, if any employer should announce his policy of discrimination by a sign reading whites only in quotes on the hiring door, his victims would not be limited to the few who ignored the sign and subjected themselves to personal rebuff. When a person's desire for a job is not translated into a formal application solely because of his unwillingness to engage in a futile gesture, he is as much a victim of discrimination as is he goes through the motions of submitting an application, close quote. But I would add this to that. She testified that she was physically exhausted and that she could not pass that test physically within 24 hours, which is what they were asking her to do. I also would think in this line of a Black person applying for a job and is fired, and let's say, we don't hire Blacks here, but we do have a rule that you can reapply, and she elects or he elects not to reapply. Would we say that therefore he has no standing or she has no standing to sue? That's what we have in this case. But we have more. We have a psychiatrist who's a doctor, and she's exhausted, and she knows she can't pass that test a second time. Now, why would she not take it a second time in addition? Because knowing that she can't pass it, if she does take it and if she takes it and doesn't pass it, she's going to be fired. And that's going to cause her, when she looks for another position, to defame herself. Why did you leave your last job? Because I was fired. And that's not what she wanted to do. She knew she couldn't pass that test. Why put herself in a vulnerable position that she has to defame herself after she's fired? It's better if she says, in her mind, and it's reasonable, that I'm better off saying I resigned.
How do you deal with the Clapper case, which it seems to me what she may have here is a fear of failure, or subjective fear of failure. And it says in Clapper that doesn't give rise to standing.
I don't think so. I'm not sure I know. But I don't think so. I do know that Judge Gibney stated that it does not appear to him that she would surely flunk the test a second time. That was very important in his decision on a motion to dismiss on something involving sexual gender discrimination, on something like that. He disposed of it on a motion to dismiss. And I don't think that, I think it's clear that a motion to dismiss was not proper under those circumstances. You had an intelligent woman a doctor, a psychiatrist. There's no reason to believe that she's dishonest or lying about it. She can't pass the test within 24 hours, and she knows about that. Now, that didn't impress the court, fine, but the court put itself in the place of a jury. While it didn't impress the court, it could have impressed a jury. And I think the court was taking the role of a jury and was speculating.
But the problem here is that there are some basic questions of law, and one involves standing and whether there's an adverse employment action or whatever, and the whole way in which Clapper figures into standing, and the other is the difference between the way in which the federal sector the statute as it applies to federal employees is worded differently from the statute as it applies to private sector employees. And so I understand your point about the jury, but the problem is there's some serious threshold questions of law, which I think the district court was bound to consider. I can't see any red lights. Has your time expired, or do you still have more time?
It expired some time ago.
Okay. Well, thank you, Mr. Levitt. And unless one of my co-panelists has some questions, we'll hear Mr. Lucier from him.
I don't have any questions.
All right. Mr. Lucier.
Good morning, Your Honors, and may it please the court. My name is John Lucier from the U.S. Attorney's Office in Richmond, and I represent the appellee, the Department of Justice. Dr. DeCoco lacks standing to bring her Title VII and ADEA claims, disparate impact claims, because she did not plead that she suffered an adverse employment action that was caused by the allegedly discriminatory conduct. And that is a physical abilities test.
Can you talk just as an initial matter before you get into the analysis of why this was done at the standing stage as opposed to the 12B6 stage? And the Supreme Court's been pretty clear that you can't conflate the merits of the claim with the standing analysis, right? In Trump versus Hawaii and otherwise, they've been clear that they're not the same. You have an arguable claim versus do you have a claim that would survive a 12B6 are different questions. Help me understand why the district judge here didn't just conflate those two, and may well be precisely right on a 12B6 standard, but that's not a standing inquiry.
Well, Your Honor, just as an initial matter, we made a 12B6 arguments that's basis in the record as well. The district court went onto the standing side. And I think in this case, the district court was correct to do so. And that's because all of the information that the court would have needed to make that determination, the standing determination, and particularly was there an injury that was causally connected to the complaint of conduct, was apparent on the face of the complaint here, taken as true at this stage. And so
right, but the question is, so let me ask it maybe a different way. Is your argument with respect to an adverse employment action that the district court relied on for standing purposes, is it any different than your 12B6 argument, or do you agree that those two arguments are identical? Whether it is a constructive discharge or not, we look at it the same way at a 12B1 standing as a 12B6. Is that your argument, or is there a difference between the two arguments you're making?
I don't know. I don't know identical. I think substantively the same for purposes of the argument that we are making with
If not
respect to
identical,
causation.
what are the differences? So help me understand what the difference would be at a 12B6.
The reason I say not identical is I'm just not 100% sure that I can say that. But practically identical. I mean, there's no difference in the analysis here because
is the standard any different? I mean, is the bar higher or lower for one?
in this case, Your Honor, no, because of the way that the complaint was pleaded. So conceptually it may be, but as applied in this case, no, those two, a 12B1 standing analysis and a 12B6 plausibility analysis in this case are the same. And it may be all identical, Your Honor.
Can I ask you one more question, then I'm gonna be quiet and let my colleagues talk. So I asked your colleague this question, and I'm not referring to the ADEA, but on the Title VII claim, on J11, the plaintiff alleges a violation of 2000E2, and that plainly does not apply to a federal employer like the BOP. There may well be a claim under 2000E16, but there's not one under 2000E2. Am I right? First, am I right about that? And second, if I am right about that, do we have the ability to evaluate whether a claim under E16 would survive, even though there is no such claim in this complaint?
Judge Richardson, you are right about that. The complaint cited the private sector Title VII provision and also, I believe, the private sector ADEA provision. We responded to the complaint nonetheless and addressed the complaint as having pleaded the correct statute. The analysis, were you to apply, the private sector analysis is very different from the federal sector analysis, Your Honor. So if we would have said, well, here's the standard under the private sector statute, it would have been a whole different thing. But we treated the complaint.
So in essence, you waived the argument that he pled the wrong statute and construed it liberally. And this isn't a complaint of you, by the way. I'm not asking you to nitpick plaintiffs, right? I in part commend you for doing it. But you basically said, okay, but we're going to treat him as if he charged or alleged the right statutes, and that's how the district court treated it below, and the parties have briefed the case.
That's correct, Your Honor. We just thought, the complaint could have easily been amended and replaced the citation, and so there was no point.
Mr. Lucier, isn't it also possible that Gomez Perez would allow him to proceed in the federal sector provision?
Judge Floyd, Gomez Perez, no, we argue in the briefs because Gomez Perez addressed an instance of intentional discrimination, and the distinction, as Judge Wilkinson pointed out in questioning Mr. Levin, the differences between the based on age language, therefore applying to intentional discrimination, as opposed to disparate impact discrimination. So Gomez Perez would not extend to the disparate impact claim scenario. On the standing as opposed to the ADEA sovereign immunity side, on the standing side, the key point in this case, as alleged in the complaint, Dr. DeCocos claimed that the BOP's test has a disparate impact in that females and over age 40 applicants fail the test at disproportionately higher rates. But she doesn't plead that she was asked to resign for having failed the test. What she instead pleads is that she had two chances to take the test, failed the first, then voluntarily declined taking the second, and specifically alleges that she did so because she feared that in her exhausted physical condition, she would be unable to complete it in a satisfactory time. Declined to take her second, and only then, only after having declined her second chance to take the test, was asked to resign or be terminated. So as Dr. DeCoco pleaded her claim, what the BOP did, the action by the employer here after her first failure, was not an adverse employment action. It was the BOP gave her the second chance to take the test, which she then voluntarily declined. That break in the causal chain is what deprives her of standing as she has pleaded it in this case.
What about the Clapper point, the point that's made in Clapper that a subjective fear of failure doesn't give rise to standing, because there are all kinds of people that say, well, it would be, futility is a very broad claim. You can say, I just can't do this because it's futile, or I'm not gonna comply with this particular office rule or particular regulation or whatever. It would be futile for me to go through the hoops. And I thought that the Supreme Court in Clapper was trying to keep this futility argument from expanding beyond all reasonable bounds, because there are lots of things in everyone's life where you might have to take a test, or you might have to pass a physical exam, or you might have to do this or do that to prove your qualifications. And if you just sort of give up on it and say, well, it would be futile, then that really punches a big hole in the ability of institutions, of which a prison is one, to sort of enact rules with which people employed by the institution must comply. So this futility thing, if it gets rolling, it just makes governance a more difficult thing to do. And it makes institutional governance much more difficult to do. And I think Clapper was responding to that concern when it said that a subjective fear of failure, which is what I think you have here, doesn't give rise to standing. I thought that you can sort of look at standing in two ways here. I think one is what you pointed out, which was it was an absence of a causal connection. It wasn't any kind of discrimination or whatever that led to the fact that she left. It was the causal agent was the failure to take the second test. But then there's also the Clapper problem, and one could be pled, I suppose, under 12b1, and one could be dismissed under 12b6. But it did seem to me that they were getting at the same thing. What is your comment with regard to that? I know you've touched on it in your earlier comments.
Judge Wilkinson, you're exactly right that Clapper, and that is that subjective fear is not sufficient to confer standing by itself, applies here. And I think that the reason that it applies here is because she, as she's pleaded it, she didn't complete the test. She didn't complete the application process. So as sort of a threshold matter, well, she, in this case, and any plaintiff who doesn't complete an application process, who in turn is claiming disparate impact, has a threshold issue. You'd have to get sort of past that. Well, then you didn't finish applying, or you didn't apply at all. How could you have been injured by a rejection? You have to get around that. And there are ways that in the law for plaintiffs to get around that, specifically the futile gesture doctrine. And what that says is that you don't have to apply if an application would be, you would face certain rejection from that application. And conceptually, that's similar to how Clapper plays in here too, because what she's saying is, what she's pleading rather, is I didn't take the second test because I feared that in my exhausted state, I wouldn't pass it. That fear is not sufficient here under Clapper, because she has also pleaded that the overwhelming majority of all people, females and over age 40 included, pass the test.
Wait, but counsel, I just want to make sure I understand this, right? So Clapper's a case where the subjective fear was not supported by any like actual, in that case, surveillance, right? And so it's not certainly impending interception. But here it's slightly different, right? Because she took the test, she failed the test, right? And so this isn't merely a subjective fear, right? She actually took the test, she failed it, and they asked her to take it again, and she says, listen, I can't pass it, right? I mean, that to me does not look like this purely subjective inquiry that we talk about in Clapper. Instead, it would be as if in Clapper, they said, yes, we know, here's the evidence that we've been intercepted for the last 6 months, right? Maybe we don't have absolute certainty that we will be intercepted next month, but we've been intercepted 6 months in a row. And so we can reasonably say, not just subjective fear, but it's a reasonable conclusion that there's a certainty of impending interception given what happened in the 6 prior months. Same thing here. There's certainly more than just a mere bald subjective fear, no?
Judge Richardson, that and the relation that how Clapper relates to the futile gesture doctrine is sort of the next step of what I was going to say, and that is that the injury here, because it's a disparate, the claim here, because it's a disparate impact claim, is a policy that falls more harshly on one group than another, and therefore harms members of that group or that class. So the subjective fear here, the reason that Clapper applies is because it's an individual subjective fear, because for the class, the complaint also shows that the overwhelming majority of people pass it. So an
interesting thing here too is that a lot of times people do better on a second test because they know what to expect. You fail the bar once. A lot of people fail the bar first time out. Then they take the bar again, and they pass. And part of the reason that they pass probably is because they're more familiar with what the bar is going to be asking. And the same goes with the old SATs. A lot of people, and the LSATs, a lot of people take them 2 and 3 times to get a presentable score. So it does seem to me that you can't just say, well, every time you've been asked to take a second test, that could still involve a subjective fear of failure. A lot of people have a subjective fear of failure after they failed it once, but a lot of people do a whole lot better when they take tests twice. That was true with the physicals in the Army. There were a whole lot of people that didn't pass. You had to pass a certain test to get out of basic training, and a lot of people didn't pass it the first time. And they did. They passed it the second time. They knew what it was all about. So I do think that there are twin factors that flow in here, and one is is plausibility under 12b6, and the others, Clapper under 12b1. That seems to me a threshold problem. But excuse me, Mr. Lucier, I didn't mean to throw your argument off track.
No, sir, not at all. Related to that, Judge Wilkinson, I mean, there is, and this is responding to Mr. Levitt's both in briefing and then in his presentation today. This would be, if you find for the appellee, this would be a very narrow decision because it's based on particular facts as pleaded in this complaint. What I mean by that is this would not foreclose claims for disparate impact generally, of course not, but it also wouldn't foreclose claims when someone doesn't complete an application process or doesn't take a second test. That's already accounted for in the law under the feudal gesture doctrine. But the facts that one would need to plead to come within the feudal gesture doctrine are just not in this complaint. That she was not faced with certain rejection on the second time. And the reason that we know that is because she also pleaded that the overwhelming majority of people in her groups, the at-issue groups here, female and over age 40, pass. So it would not have been futile for her to complete the application process under these specific facts. And indeed, she says the reason I didn't take it the second time was because I feared that I was exhausted and therefore I would fail, which is an individual subjective fear for a claim that relates to class-wide harms and class-wide disparate impacts. And so this is a very narrow case at the end of the day. The law already allows for people in certain instances to not apply or to not complete tests and still bring disparate impact claims. That's just not facts that were pleaded here. That's all.
All right, thank you, Mr. Lucier. If my co-panelists have no further questions, I'd like to hear from Mr. Levitt in rebuttal.
Thank you, Your
Honor. All right, Your Honors. This case does not involve someone taking a second test and being able to answer questions that she or he didn't answer quite properly in the first test. That's not what this is. This is a physical abilities test from a doctor and a psychiatrist within 20, but unlikely is she lying. And she has a good reason not to take a test that she feels is not simply fearful, but is she won't be able to pass it 24 hours. And that's the difference of all these other cases. But also important here, when you go back to the early days of Justice Black and Justice Douglas, and the early days of handling racial discrimination in the factories, where the Black employees got the lesser jobs and the whites got the more important jobs. When you go back to that, that's what we're talking about here. Not black and white, we're talking about male and female. And the Supreme Court stated in Mississippi University for Women versus Hogan, quote, parties who seek to defend gender-based government action must demonstrate an, quote, exceedingly persuasive justification, close quote, for that action. And there are other Supreme Court cases that we put in the brief where how going back for a second bite at the apple won't work. And this is one of those cases. Now, Judge Gibney dismissed on a motion to dismiss without prejudice, but not without giving his opinion and speculation. And his opinion and speculation, which only a jury should have done, is that it doesn't appear that she might not have been able to pass the test a second time. So said Judge Gibney, although the latter one might be the correct one. And that's what we have here. And one other thing, the preamble to the requirement for the test by the government in this case was that everyone's going to be a law enforcement officer in a time of emergency, and so you got to pass it. What happens if you take it and you pass it? When do you take it again? Never. You never need to take it again. Once you have passed the initiation, you're in the fraternity. You're a fraternity member for life. You passed it. Once you pass it, you never have to take it again. You can develop all kinds of weight problems, physical problems. You're in. You passed it. You're in the fraternity. That's what's involved in this case. And that's what concerns clearly the Supreme Court in more than one decision. And they're going to read that language in the ADEA, and they're going to say it's got to mean something and can't be rewritten by anyone except Congress.
All right, thank you very, very much, Mr. Levitt. We appreciate that. And if my co-panelists have no further questions of you, I'll ask the courtroom deputy to adjourn court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.